Good afternoon, everybody. I would like to take this opportunity to thank you for joining us and to introduce our speaker, Steve Wilkes. Steve is with the law group, the Wagner Law Group, a prominent ERISA law firm, and Steve is based out of their San Francisco office. Steve has worked with NCS and many of our clients over the years on those tricky ERISA issues that seem to come up from time to time. Steve has been practicing law for about 30 years now, and he works with a national base of clients, including broker-dealers, registered investment advisors, financial institutions, as well as plan sponsors. His practice includes an emphasis on all the issues that arise in the financial service industry involving investment products and services aimed at the retirement sector. Steve will discuss the recent DOL proposal for a new definition of fiduciary status and how its implementation will impact our industry. We look forward to hearing what Steve has to say about this. This presentation, by the way, will be available in the NCS library underneath the webinar heading. So I'd like to turn this over to Steve. Steve, why don't you take it from here?
Thank you very much. Ken, can you hear me? I hope everyone can hear me okay. Good afternoon, and welcome to today's webinar. It's a pleasure to be associated with NCS and Ken and his colleagues there. We'll be covering the DOL's new fiduciary proposal, which has been called a potential game changer for the whole industry. Now, people are still trying to digest all of its implications, but it's clear that this proposal is going to be one of the most significant and groundbreaking pieces of rulemaking that we've ever had from the DOL. It's designed to broaden the scope of retirement advisors who are deemed to be fiduciaries under ERISA, and it's also designed to address their potential conflicts of interest when advising their retirement clients. Now, the scope of this proposal is very far-reaching, and it specifically covers and protects IRA clients as well as, ERISA-governed plan sponsors. As a formal matter, this proposal includes, it's a lot of material. It includes a new regulation defining what fiduciary investment advice is, 2 new class exemptions for prohibited transactions, and significant amendments to a number of existing exemptions. So what I would like to do today is, put the proposal in context by giving a big picture view and then discussing it in a little more detail, the existing rule, then navigate through the definition, some of the carve-outs, the applicable exemptions, and the timeline for the proposal. So I think because this is a proposal currently, let me start out by saying that because this is a proposal still, I would encourage people to sit back and really think about the different pieces of it that might resonate for the products or services you provide, think how it might impact you. Well, I think we'll know with a little more certainty after the DOL has hearings in late July as to where this is gaining traction and what's going to happen. I personally think that the regulation will come through in some shape or form pretty close to where it's at now, but there's a lot of politics involved. For those of you who read the paper, Secretary of Labor Perez had a tremendous grilling in the House yesterday on this regulation. So there's still a lot of controversy and a lot of discussion around it. But I think that in this form or some shape close to it, we're going to see something before the Obama administration leaves office. And so to that extent, we don't want to be too late or too early to act on it. This is just a good time to really evaluate its impact. And as I said before, I think once we get through the hearing stage, we'll know with a lot more specificity as to how it might impact, a particular situation and what kind of things you might be doing now. So this has been around for a while. The original definition of fiduciary was established by the Department of Labor back in '75, just after ERISA was enacted. Now, 40 years ago, when the original fiduciary rule was put into place, the industry looked very different. Products and services were all developed in a context very different from today. I would point out as a corollary that the Advisors Act and the Securities Exchange Act and a lot of the rules of the self-regulatory bodies such as the NESD, now FINRA, were also based on this kind of old platform. You know, the common practice back then, you know, registered investment advisors provide advice for a fee, and broker-dealers effected transactions for a commission. And back then it was really easy to distinguish, you know, advisory versus brokerage activities. And brokers generally took the position that they were not providing fiduciary advice under ERISA, or if so, it was just incidental to their affecting a securities transaction. So, you know, back in 2010, the DOL issued a proposed regulation, as I'm sure many of you remember. It expanded the definition considerably, and it would have impacted a lot of advisors who didn't see themselves at the time as fiduciaries. There was a vigorous industry debate. Congress, the executive branch, the Department of Labor all weighed in, but eventually the DOL decided to withdraw that regulation and reassess its position. So now, here we are, you know, about 5 years later, and the DOL has now issued a new proposal, or a reproposal, if you will, for the definition of fiduciary. And as you'll see, it represents a significant regulatory push toward a universal standard for all types of advisors. This proposal basically, it almost like divides the plan world into two groups, you know, plans that need protection and those that don't. And although, you know, some people might question whether these protections are necessary at all, to the extent that you think this makes sense, clearly there will be some comments and maybe some improvements along the line, along the likes of where this dividing line is drawn, and, you know, which rules are applicable to which group of plans, meaning, you know, IRAs and smaller plans versus larger plans. But under this proposal, pretty much every conversation with the plan, every dialogue, every communication is potentially deemed to involve some form of investment advice that's customized or tailored in such a way that, you know, pretty much all the service providers and counterparties to plans who historically didn't see themselves as fiduciaries or found some comfort under the existing regulatory framework, they're going to end up being fiduciaries. That's where it's heading. And sales, marketing, you know, generalized market observations, this stuff might even be deemed to be conveying investment advice. So this, you know, this proposal is going to really expand the reach of the fiduciary standard under ERISA for, you know, a higher level of duty, if you will, and the prohibition on prohibited transactions. And again, it could apply to all kinds of sales personnel and bankers and other service providers, even if contacts are limited. So if the service provider is deemed to be an investment advice fiduciary, it can no longer earn compensation, you know, directly or indirectly coming out of that advice. You wouldn't be able to sell proprietary affiliated products without violating ERISA, without incurring, you know, excise tax. So a lot of, you know, the impact is very broad. Now, what are some of the, just quickly, you know, what are some of the impacts to this? Well, like I said before, pretty much every bank, broker-dealer, you know, futures dealer, merchant, money manager, trustee, even people at call centers, record keepers, they're either going to have to really hold back on their written and oral communication with plans and IRAs, which might include a lot of their sales and marketing stuff, in order to comply, and you know, so that they either avoid fiduciary status, or they're going to have to comply with one of these new exemptions under the regulation, and they're going to have to, you know, restructure what traditionally had been a non-fiduciary business into a fiduciary business model. This regulation is going to limit the availability of the use of some of our existing prohibited transaction exemptions, because a very common condition to a lot of these exemptions is that one of the parties involved, you know, might be a service provider but not a fiduciary. It's going to change the appraisal fairness opinion game quite a bit because of the way fiduciary activity is written. It's going to really impact in the IRA rollover world with a very broad reach. We'll talk about that a little later. It's going to reduce the kind of investment education that is not deemed to be investment advice, and that's going to be a huge change for everyone, including advisors who otherwise are not, you know, impacted as heavily as say, broker-dealers are. It's going to cause a rewrite of several of the existing class exemptions that are used in order to accommodate the new definition. So I think it's safe to say that all the service providers, pretty much all service providers are going to be presumed to be providing investment advice, and they're all going to be kind of, presumed to be fiduciaries, unless a carve-out is applicable or there's an exemption available. And there are carve-outs for certain, for swaps and platform providers. We'll talk about those in a few minutes, and that's going to help a little bit. But they're kind of limited to very select transactions with plans that have 100 or more participants or plans that are of a certain size with an independent fiduciary. And then, these new exemptions that you've been hearing about, it's going to require people to either accept ERISA fiduciary responsibility, even with regard to IRAs. People are going to have to sign on to, new best interest and conflict provisions. It's going to cause a restructuring of a lot of the common compensation arrangements that we've seen, which might not work under the new reg. People are going to have to make warranties that they don't violate any law. Disclosures will be increased significantly beyond what you thought under 408B2, including certain annual disclosures that have to go on, the website. The record keeping is going to go up. I think it's going to impact the kind of access that plans and IRAs will have to products and services on a cost-effective basis anyway. We may end up with fewer investment opportunities for smaller plans and IRAs because people want to play it safe. IRAs and a lot of plans might be forced to move over to, fee-based or wrap accounts and away from commission arrangements. This regulation effectively gives us a de facto list of permissible and impermissible products and services for these smaller plans and IRAs. And it's going to impact the way financial institutions handle their internal inventory of debt and other structured products, unless they're making the sale to certain, very large plans. And it's going to change, the way mutual fund fees are distributed. So it's going to be quite significant, and I know you've been hearing a lot about it. Let me see if I can work back through and give you some of the specifics now on how it's all going to go. Excuse me. So, as you know, currently, if you're deemed to be providing investment advice relating to plan assets for a fee or other form of compensation, you're deemed to be a fiduciary and subject to a very high standard of care under ERISA. And this existing DOL definition, has a 5-prong test that has to be satisfied in order to become a fiduciary. So this means that, the 5-prong test, the advisor would need to be making recommendations as to investing in securities or other property, give advice as to, the value of security or other property on a regular basis. There must be a mutual understanding that the advice will serve as the primary basis for the plan and that the advice is individualized to the particular needs of the plan. Now, the DOL has always felt that this definition is just too narrow in today's world, and that it allows many advisors to give advice without having to answer to the fiduciary standard of care under ERISA. I think the DOL understands that there are many, many, many really fine advisors in the field, and they also seem to be concerned that some are better or have a different set of priorities than others, and that's what they seem to really be chasing after. So they feel as though people could engineer their way around through the fine print and avoid fiduciary status. So, for example, an advisor could take the position that its advice is not based on a, quote, regular basis, or, that there was no, quote, mutual understanding that the advisor's recommendations would serve as the, quote, primary basis for the plan's decisions. So because this definition makes it so narrow, the DOL thinks it's too easy to escape fiduciary status, and therefore that what the DOL is trying to do now is expand this definition considerably to include a much broader group of advisors. So under the proposed rule, just like with the existing rule, a person who provides investment advice for compensation is still viewed as a fiduciary, but under the proposal, the DOL is clarifying that a person can be a fiduciary by providing investment advice to plans, plan fiduciaries, plan sponsors, participants, IRAs, and IRA owners. The regulators have always taken the position that fiduciary advice, that fiduciary advice covers advice to plan sponsors, participants, and IRA clients. So this is simply codifying, or I should say memorializing the DOL's position in a regulation, you know, as it's been reflected in its other published guidance. But under this new proposal, the definition of investment advice is really broadened, and it becomes now a four-pronged definition, and you are providing investment advice if you're making the types of recommendations that are covered by the rule, which we'll talk about in a little bit. And there merely needs to be an understanding that the advice will either be individualized or specifically directed to the recipient. I'm not sure what specifically directed to means. I mean, a marketing piece is specifically directed to people. I'm not sure what they mean by that exactly. But if it's individualized, specifically directed to the recipient for consideration by the recipient in making investment decisions, there no longer needs to be a mutual understanding between the parties that the advice is the primary basis for planned decisions. So obviously the net's getting expanded. And under the existing definition, you know, investment advice only covers recommendations relating to investments and their value. But under this new proposal, it broadly covers four different categories. First, it covers recommendations relating to securities or other property, just like the existing rule. But the DOL is clarifying that it will also cover recommendations to take rollovers from a plan, as well as investment recommendations for rollover assets. The IRA rollover treatment and impact is one of the most significant potential impacts under this regulation. This new proposed definition also includes recommendations relating to the investment management of the assets of a plan, including rollover assets. And it also, so in other words, this means, you know, recommending an investment manager will also count as covered advice. And that's something that a lot of people, you know, were a little bit unsure about in the past, even though the DOL has put it in the preambulatory language of several of its proposed and final regulations. Third, giving financial valuations, appraisals, and fairness opinions for any investment held by a plan or an IRA will be viewed as a covered recommendation. And lastly, recommending a person who provides any of these three services for compensation will also be considered covered advice. So a person who recommends an advisor who in turn recommends investments or investment managers or provides appraisals would be an investment advice fiduciary under the newly proposed four-pronged test from the DOL. Now, the DOL proposal provides an alternative way in which an advisor might be deemed to be a fiduciary providing investment advice. Specifically, if the advisor makes a covered recommendation, such as an investment recommendation, the advisor will automatically be deemed a fiduciary if it represents or acknowledges in writing that it's serving as a fiduciary with respect to the advice that's being provided to the plan or IRA. Now, this representation, the representation or acknowledgement does not need necessarily to be in writing. It appears as if an advisor were to verbally hold itself out as a fiduciary. This might also be sufficient to convert the advisor into a fiduciary. I think it's important to highlight here that a representation or acknowledgement is all you need to trigger fiduciary status. Even if the advisor doesn't meet the four-prong definition, if he or she or it will be, you know, makes this representation that it will be deemed to be a fiduciary with respect to, you know, the applicable plan or IRA. If an advisor were to publish an investment newsletter to the general public stating that it contains fiduciary advice, that advisor might be deemed a fiduciary to those readers with IRA accounts, even though the newsletter advice is not individualized or specifically directed to any particular client. Now, let's think about this DOL proposed definition a little bit. I mean, this really does broaden the scope of what advice is all about. Even one-time advice that is not provided on a regular basis could potentially be viewed as fiduciary advice. There's no need for a mutual understanding, like we said before, between the parties. It's simply enough for a plan or IRA client to think on its own, unilaterally, that the advisor is providing fiduciary advice in order to trigger this status. It doesn't even need to be individualized. The advice only needs to be specifically directed to that client. And also, you know, if the advice no longer needs to serve as the primary basis, that's a big change. As long as the client considers the advice when making its decision on behalf of its plan or IRA, that'll be sufficient. It doesn't have to be primary. It could just be a piece or part of the process. Finally, we should just note that the existing definition clearly covered investment recommendations, but it omitted investment management recommendations. And because of this literal wording, a lot of advisors took the position that recommending investment managers as opposed to investments was not a fiduciary act. But like I said before, DOL has always taken the position that this is covered advice, and now they're simply, you know, formalizing it, putting it into the regulatory language. So you can see that that is really, really broad. Advisors out there, investment advisors listening, you, for the most part, acknowledge your fiduciary status under the Advisors Act and as an ERISA fiduciary. Not a big change there, but obviously, you know, insurance consultants, salespeople, broker-dealers, that's really, really different. Now, there are some carve-outs, some specific carve-outs from this definition. The DOL has proposed 6 of them, and if you fall into one of these 6 categories, you won't be deemed to be a fiduciary even if you're providing investment-related recommendations to a retirement client. There are carve-outs for counterparties, including counterparties to large plans, as well as swap counterparties. There's also a special exclusion from the fiduciary advice definition for employees of plan sponsors. Platform providers, like record keepers, are eligible as well. Financial valuations and appraisals are excluded, and investment education is also carved out from the from this proposed definition. This is also, in my view, one of the big changes here that's going to be very impactful. We'll talk about it a little bit later. Of course, if a person or a firm let me start again. A person or firm won't be eligible for exclusion from this investment advice definition if they represent or acknowledge that they are acting as a fiduciary when advising. So, for example, if a swap counterparty, such as a bank, were to hold itself as a fiduciary to a plan sponsor, the bank would automatically be deemed to be an investment advice fiduciary, even if it otherwise satisfies the substantive conditions for the carve-out. So that goes with what I said before. If you're acknowledging your fiduciary status, you can forget about the other definitional pieces. So under this proposal, if a person is acting as a counterparty in an arm's length purchase, sale, or loan with the plan, that counterparty may provide advice without being deemed to be an investment advice fiduciary by complying with certain conditions. For example, if a broker-dealer were to sell a financial product from his inventory to a retirement client, the broker-dealer would be a counterparty to that client, and it would be permitted to provide related advice without being a fiduciary by complying with the requirements of the carve-out. So what are they? First, the advice would need to be limited to the purchase, sale, loan, or the actual contract between the counterparty and the plan. Second, the plan sponsor or some other plan fiduciary must provide a written representation that the plan has at least 100 participants and that it has sufficient expertise to evaluate the transaction and that it won't rely on the counterparty to act as a fiduciary. This written representation isn't required if the plan fiduciary has at least $100 million of assets under management, and that's taking into account all the plan client assets under management if the plan fiduciary is managing the assets of multiple plans. So this is where you can see where there's a notion that's been building at the DOL for a while, and it continues to build. We see it like on some of the exemptions for performance compensation, that there is a certain place for large, sophisticated plans, people with some independent means and independent fiduciary structure to make a decision, to kind of, you know, let them go ahead and make some decisions, you know, on their own, you know, under a good process, and then and move forward. Now, a counterparty has to inform the plan fiduciary of the nature of the counterparty's role in the transaction. No direct fee may be paid to the counterparty from the plan in connection with the transaction. And it should be noted that this carve-out would not apply to agency services like a broker providing fund recommendations for 12b1 fees. There's also a carve-out for swaps. These are derivative transactions. A lot of institutional plans utilize swaps on a routine basis. A plan in a bank might enter into an equity swap where there's an exchange of the future cash flow value of an investment. You know, one might be linked to an equity investment like the S&P 500. The other is a floating interest rate investment like LIBOR. And the carve-out from the proposed investment advice definition for these counterparties covers any related advice provided by the swap dealer, as well as a security-based swap dealer and major swap participants. But to qualify for this exclusion, the swap dealer or major swap participant must be acting just as a counterparty and not as an advisor to the plan in connection with the swap, in line with the applicable regs under the Securities Exchange Act and the Commodity Exchange Act. And under the DOL proposal, employees of a plan sponsor will not be deemed to be fiduciaries with respect to any advice given to the plan sponsor relating to the plan and its investments. And this is pretty straightforward. You know, some employees, part of their job description is to, you know, work on internal plan matters. You know, it could be in the Treasury Department, the HR Department, but to qualify, the employee in this instance must not receive any compensation providing the advice beyond normal compensation that they would get as part of their salaried compensation. There's a carve-out for platform providers. This applies to providers of investment platforms, you know, typically for DC plans with participant-directed investments. So, for example, this would work for a 401k record keeper platform. As long as the conditions are met, the platform provider would be able to offer and market investment funds from its own platform, which in turn may be offered as investment alternatives to participants. The provider would need to market these investments without regard to the individualized needs of the plan or its participants. The provider is simply saying, hey, here's what I have to offer, they're available to you, you choose them. And the provider would need to disclose in writing that it's not undertaking to provide advice or to give advice in a fiduciary capacity, it's simply making them available. So under this carve-out, the platform provider is permitted to identify investment alternatives that meet objective criteria that are specified by the plan. You know, like a plan might say we want investment funds of a certain size or within certain expense ratio tolerance levels, and that's okay. A platform provider could identify those. It's not recommending them, it's simply identifying them in satisfaction of the criteria provided by the plan. And the provider can also give objective data on the investments, you know, about the investment performance and certain benchmarking comparisons. There's a carve-out for financial valuations, appraisals, and fairness opinions. And there's a carve-out for there's also a carve-out for certain ESOP valuations as well. This is going to be big, the carve-out for investment education, because I think this is an area where a lot of investment advisors who didn't think they necessarily had to change their game that much based on what they've heard so far. But, you know, many investment advisors deal on a fiduciary basis with the plan, and then they're on a non-fiduciary basis with plan participants, providing education and support at annual meetings. So the education game has changed a little bit. The proposed carve-out, it's based on the existing safe harbors that we see under the current, DOL Interpretive Bulletin 96-1, and it provides, just like the current safe harbor, there are 4 categories of guidance that are okay. This includes plan information, general financial type information, asset allocation models, and interactive materials such as calculators and questionnaires. By the way, the carve-out, we should point out to you, this also applies to plan sponsors and IRA owners as well as to participants. So the carve-out expands the scope of non-fiduciary education by also covering guidance for assessing retirement income needs and strategies for managing assets in retirement. And that's good. And the proposal makes it clear that in order to qualify, the investment education must not recommend any specific investment products. That's sort of the change, because under the existing safe harbor, an asset allocation model, for example, which is a very common vehicle used for education, could be provided, and certain interactive tools could be provided, and they might make reference to specific investment alternatives that are already available under the plan, as long as there was a disclaimer and some disclosure accompanying that wasn't the only option. But under the carve-out, in no event can any of these educational materials make any reference to specific investment alternatives. So the way that people have been educating by saying, here's an allocation model using some of the stuff that's offered under your 401k plan, won't be able to do that anymore, at least as is proposed right now. I think that's a huge change. Now, in addition to redefining the definition of fiduciary and having the carve-outs, there's a lot going on in the exemption world. The DOL understands that we need some exemptive relief for advisors who don't currently hold themselves out as fiduciaries. So the DOL has released 2 brand new exemptions and has amended several of the existing exemptions. And they're extremely complicated, and we're going to go through them in a minute. But the reason they're there is because, currently under the law, it's unlawful for any fiduciary to earn variable compensation, based on the investment that it makes or the advice that it gives. So an advisor would only be permitted to earn variable comp if we're able to qualify for an available exemption. So what they're doing is the DOL to kind of, allow for variable compensation to try to maintain some semblance of the current compensation scheme. The DOL has proposed what's called the best interest class exemption. This is designed to give relief to advisors who earn commissions primarily from retail clients. So this would include participants and IRA owners, sponsors of non-participant directed plans with less than 100 participants, like a small defined benefit plan. But as you've just noticed, there's an exception here. This exemption was designed to cover retail clients, but it doesn't include the sponsor of smaller 401k plans and other plans with participant-directed investments, and that's going to be a big hole that we'll see how that gets fixed, during the comment period, if at all. So we think that there'll be a lot of pressure to get some relief here. Because without any relief, advisors won't be able to earn commission-based comp from any defined benefit plan or defined contribution plan with 100 participants or more. Now, this BIC, best interest exemption, is extremely complicated, a lot of details. Let me see if I can give you a little bit of a big picture of it. The relief under this exemption is specifically restricted to certain listed investment products. So they're identifying bank deposits, CDs, mutual funds, ETFs, bank collective vehicles, insurance company separate accounts, exchange-traded REITs, certain corporate bonds that are registered, and publicly traded securities. It also covers, treasury and agency debt securities. It also covers insurance and annuity contracts. So when you think about this list, you'll see that a lot of privately placed debt securities, non-traded REITs, alternative investments are omitted. So if the DOL proposal comes through in this current form, it's possible that some of the investments that are currently sold on a commission basis, to IRA and plan clients, will no longer be eligible. This will be a pretty heavy impact on the broker-dealer world. So we're expecting to see some comments on this as well during the comment period. Now, one of the big requirements of this exemption is that there be a written agreement between the advisor and the client, and there's a list of the required provisions in that agreement. The advisor has to acknowledge that it's a fiduciary for purposes of ERISA with respect to the advice that it's giving. The agreement must incorporate what we're referring to as the, quote, impartial conduct standard, close quote. And this means that the advice will be provided in accordance with the best interest standard under ERISA. So they're really trying to, transport basically the ERISA fiduciary standard over here under this exemption. And it must provide that the advisor will only earn reasonable compensation and that no misleading statements are made. There are various warranties the advisor has to make. Has to warrant that he or she or it will comply with all federal and state laws. It must warrant that it will have to adopt compliance policies that are reasonably designed to mitigate conflicts, and that it has eliminated any incentives that would encourage the advisor to make recommendations that are inconsistent with the best interest standard. And the agreement must not limit the advisor's liability for contract violations. The agreement must contain an it's okay to have arbitration as long as there's no waiver of the client's right to participate in class action lawsuits. So there is a lot there. I mean, we could take an hour and just talk about these provisions and what they really mean, but this is really, it's all aimed to protect investors and provide for transparency, but that's a lot going on in terms of that written agreement. There are certain disclosures that have to be made. It has to identify conflicts of interest. It must disclose the client's right to obtain complete fee information from the advisor. It must indicate whether the advisor is offering, its own product, proprietary product, or receives any third-party compensation, I should say, such as revenue sharing. It also must include the address of a web page which discloses all the relevant compensation information. And it also, the advisor must also provide certain transaction disclosures. There has to be an upfront disclosure with a chart displaying the cost of making the recommended investment for 1, 5, and 10-year periods. Now, the DOL put a model chart in the proposal. Some of you might have seen this. Its use is not mandatory, but it's really helpful to look at it. Annual disclosures of all investment and fee activity must be given to the client, and the advisor has to maintain a web page with disclosures of compensation from all investments held by the client during the preceding 365-day period. Wow, that's a lot of information. It's useful, it's important, but that's a lot to carry to keep this exemption available. And I think also, you know, the advisor, just generally, the advisor has to offer a broad range of investments that cover, you know, all reasonably necessary asset classes. But an advisor, you know, you can have a specialty advisor. An advisor is permitted to offer a more limited range of investments if it meets certain conditions. The firm has to make a written finding that the range limitations don't interfere with the, quote, best interest standard for providing advice. So, for example, an advisor that specializes in fixed income product would probably have to, you know, would have to satisfy itself that, you know, the client had access to other asset classes and that by focusing strictly on fixed income with this client, it wasn't harmful per se. The advisor, you know, can only get reasonable compensation, and any written notice must be given to in advance, you know, to the client, which describes any of these range limitations. And the advisor also has to tell the client if the advisor doesn't recommend a sufficiently broad range of investments to meet the client's needs. In other words, the DOL is contemplating that an advisor might have limitations because, as I said before, you know, it limits this investment offering to proprietary products or investments for, you know, for which the firm receives third-party payments or revenue sharing, or maybe it's a specialty advisor. Now, this BIC exemption, best interest exemption, does involve a regulatory filing, and as proposed, there's a one-time notice to be filed with the DOL before a firm can receive any variable comp based on the proposed relief. The notice doesn't need to identify the firm's plans or IRA clients, and it doesn't need to be approved by the DOL. This needs to be filed. So there's no approval process or waiting period once the notice is filed. But there's more, you know, more paperwork, more regulatory. Now, there are some special things going on in terms of insurance and annuities. That could be a topic of its own. And in fact, we might do an insurance-only webinar in the near future because we've had some requests for those. But I would just say that, you know, when an advisor earns variable comp, you need some sort of exemptive relief against the self-dealing rules under ERISA. And so, you know, when an insurance company that provides services, you know, to a plan or an IRA client is a party in interest, you need some relief. And this proposed exemption, you know, offers the relief, you know, for these purchases, and these conditions are pretty straightforward. The insurance or annuity contract purchase must be in the ordinary course of business for the company, and the insurer must receive reasonable comp. They said the purchase must be for cash only, and, you know, on an arm's length basis. But I would just say that in general, in terms of insurance, there are some major things happening here in the insurance world. I would say number one, that, you know, they're going to be amending the current exemption 84-24. We'll talk about that in a moment. Number two, I would say that to the extent that you're recommending a distribution or a rollover involving an insurance product, you know, insurance advisors are going to be fiduciaries, and they're going to have to kind of work through the exemption rules. And there is a distinction now. There's an exemption for sales of insurance products that are securities under federal securities laws, such as variable annuities. And that used to be under, you know, that exemption is now basically transferred over to the best interest exemption away from the existing class exemption. So the whole insurance platform needs to be revisited in terms of products and services. Interestingly, you know, the DOL is responsible for defining what a fiduciary is and for granting exemptions, but it's, you know, it's the IRS that really has the enforcement jurisdiction over IRAs. So what's happened is, you know, if an advisor were to violate its fiduciary duties to an IRA, the DOL really has no enforcement power. So because of this, and in recognition of this, this BIC exemption basically gives IRA owners the contractual power to enforce their fiduciary violations by suing the advisor for, for breach of contract. So by requiring the inclusion of the impartial conduct standard in a written contract, which parallels or mimics the ERISA fiduciary standard, the DOL is effectively moving enforcement into the hands of investors who can file their own lawsuits, whereas the DOL couldn't take action in that case. And again, this best interest exemption is going to have a huge impact on brokers and insurance agents. Even if they don't have a plan client, this exemption is going to affect the way you handle personal clients with IRA money. And complying with this exemption, it might be difficult for some broker-dealers and insurance agencies. The disclosures are pretty heavy. I imagine that the industry will find it difficult to eliminate all the incentives, with different club levels of reward and recognition and what have you. They're going to find it difficult to work around those incentives that might be deemed to be encouraging improper advice. So that's another area where I'm very interested to see what the comments are going to look like coming forward later on this month to the DOL. Now, in addition to this best interest exemption, the DOL has proposed another new exemption. It's called the principal transaction exemption. And the principal exemption addresses the fact that broker-dealers will be viewed as fiduciaries with respect to their plan clients and hires. And although the best interest exemption provides relief for fiduciary advisor providing brokerage services, the BIC, the BIC exemption would not cover the sale of securities from the broker-dealer's own inventory, a principal transaction. So now they're proposing a principal transaction exemption very similar to the BIC exemption. It includes contract requirements, and it has a specific scope. It only covers the purchase and sale of certain types of debt. But that's a pretty common undertaking out there in the financial markets. So it'll be in place. It covers U.S. corporate bonds that are, available under registered offerings, as well as Treasury and agency debt securities. So again, it doesn't cover private placements of debt or equity securities or any kind of alternative investments. Now, there's a host of proposed amendments that are going to be modified and adjusted or revoked in part to kind of work with this new definition. So in general, the Department of Labor is going to be taking this new impartial conduct standard and incorporating it into all the existing exemptions, and they're going to be proposing other changes. Very technical. We're not going to get into all of that today, but I have tried to list, kind of the main exemptions that we see our clients engaged in the retirement service marketplace. 77-4, which gives relief in mutual fund purchase and shares where the fund advisor is also fiduciary. 80-83, where the fiduciary causes a plan or an IRA to purchase security where the proceeds might be used to reduce indebtedness. 83-1, mortgage pool certificates. 84-24, big in the insurance and annuity product area. 86-128, affiliated brokerage and product. And they're also, the DOL has also asked whether it should establish what it's going to call the low fee exemption, and that would be similar to the best interest contract exemption, in that it would allow a fiduciary to earn variable comp, but it would have much fewer requirements than the best interest exemption, and it would address scenarios in which the advisor recommends the lowest fee product in a given product class. So we'll see what kind of comments are going to come in on that. Now, you've all heard a lot about the time. As you all know, the timeline has been extended a little bit. So this first came out back on April 20th, 75-day notice period, ending on July 6th, was extended to July 21. And then after that, they're going to have a public hearing. And then after that, they're going to reopen for comments. But I think what's going to happen is, generally speaking, once we get to a final rule, it generally won't be applicable until 8 months after publication. So on the one hand, we could be, we're 8, 9, 10, 11, 12 months away, 13 months away, kind of depending on how things play out. On the other hand, that's a period of time in which to analyze and think how this might impact you. On the other hand, it can come awfully fast. And as I said before, my personal guess is that This will progress in some shape. It might be modified a little bit based on input, but it seems to have enough traction to keep moving forward. I know the Obama administration sure is trying hard to keep it online. For those of you that are interested, you can see, I think, in today's Wall Street Journal and some other places, you can find Secretary Perez's testimony from yesterday, the 17th, up on the Capitol Hill in front of the Education and Labor Committee in the House. Pretty strong stuff on both sides of the microphone there. So again, you know, you can just never be sure with politics. The Obama administration has made it very clear that they would like this to go forward. I would say, by the way, I happen to have the good fortune to represent our law firm and testify at the Department of Labor about 2 weeks ago on some unrelated matters involving cybersecurity and private plans, but Assistant Secretary Borzi was there, and just in terms of talking with her, you know, I think the DOL is really working hard. They've raised a lot of questions. They've asked for a lot of input. I think they really believe in what they're doing, that it's important and necessary, regardless of your personal view. I think they really are trying to serve the best interests of the investing community, and I think they're very open to some good practical suggestions. So we'll see how that all goes. Now, the SEC, by the way, as you know, they're talking about establishing a uniform fiduciary standard, and you know that would apply to both advisors and brokers. But you know, it's hard to really say that Congress will be able to delay the finalization of this proposal by forcing the DOL to subordinate its own rulemaking to the SEC. The Department of Labor has already gone on record as stating that it's already coordinated with the SEC. And like I said before, the DOL does have the full support of the White House. So even if Congress passed some legislation, you know, President Obama would likely veto it. And overcoming a veto is not a very common event in my experience up on the legislative world. So let's see if we can kind of wind up where we are today. We covered a lot of detail. I hope you sat back and just tried to listen to some big picture issues and had that aha moment where you see what resonates for your particular product or service and how you're approaching things, so you know where to focus and pay attention. The DOL is definitely trying to impose this best interest standard on all types of advisors, whether the client is a plan sponsor or a participant or an IRA owner or holder. And rather than coming up with very specific rules, this best interest contract exemption follows what we refer to as a principles-based approach. It's very similar to the way they regulate advisors on the Advisors Act side. Very heavy on disclosure, very heavy on having prudent and appropriate compensation, conflict policies in place, written policies as part of your manual. But a little bit of flexibility to kind of live and breathe and move with each situation. And of course, that has a plus and a minus. Gives you some flexibility, but sometimes you don't quite know where you stand, and that's, you know, that's the challenge. It's very ironical, really, in some ways, what the DOL is doing. If they are successful in creating and getting this proposal through, we're going to end up with basically two classes of advisors. Some earn commissions and some don't. And with regard to advisors earning commissions, you know, variable comp, you know, the conflict might be mitigated, but it'll always be there a little bit. You know, when you're on a commission basis, you're always incented and thinking about earning more. I don't think that's a fault. I think that's just an operation, just the way, you know, we all work. And a lot of clients, a lot of retirement clients might not realize that advisors can still even earn variable comp. So you end up with a universal standard for all types of advisors, but the best interest exemption, you know, kind of changes that level a little bit, that standard when it comes to, you know, brokers and insurance agents. So as we wrap up here, what's the impact? So we know on the advisor side, it's going to substantially affect advisors, even though they already are fiduciaries. It's now going to reach their IRA activity. It's also going to change the way education is delivered. And the DOL, you know, kind of on the broker side, it's going to impose, I think it's going to be very expensive and a lot of compliance costs for broker dealers and insurance agencies to kind of convert over and maintain the conditions that are necessary to satisfy the BIC. It looks like the BIC exemption is a lot heavier than what we have under 408B2. that, you know, but nonetheless, I think when all is said and done, the rule will have less impact on advisors than on broker-dealers, and that's pretty clear. So in terms of next steps, like I said before, keep your eyes open, think about how this works for your platform, your products, your services, stay abreast. Please feel free to send any questions you have to your counsel, to Ken at NCS, or to contact us if you'd like, and I'm sure that you know that you'll get an answer. This is probably a good time to at least be thinking about to re-examine, if you will, think about your client service model, your documentation, the disclosures you're making, whether or not you are a fiduciary, whether or not you want to be a fiduciary, and it's also a good time for plan sponsors to really ask the same question of the advisors, you know, how the advisors think they'll be positioning themselves going forward. So thank you very much. This concludes the webinar. Please feel free to contact us if we can be helpful, or to get in touch with Ken, and I will turn it back over to him.
Steve, thank you very much. This is a lot to think about, and hopefully you'll come back to us after the dust settles on this and give us, you know, some further insight into this. I want to